Good morning, everyone. Welcome to another session with Sharia Clinic. My name is Angela Achieng Ochieng. I'm an advocate of the High Court of Kenya. I'm also the founder and visionary of Sharia Clinic. So what Sharia Clinic essentially does is to consistently serve you with legal knowledge in a very simple way. So today I'm not alone. Today I'm joined by Ramazan Odero, who's our Wakili. He's an advocate of the High Court of Kenya as well. He's also the senior associate at JK Macau and Company Advocates, which is based in Machakos. Now, today we're going to be talking about leave without confusion, as you can see there, a Kenyan legal guide to employee leave entitlement. So we want to know what types of leaves are there and what are your responsibilities as an employer and also what are your responsibilities as an employee with regards to leave. So briefly, maybe I'll give an opportunity to Ramazan to say something before we start. Tell us more about your farm, about yourself, or anything and how our people can get to you. Thank you.
Thank you, Angela. Well, to our listeners and viewers, as you've been told, my name is Ramadan Odero. I'm an advocate of the High Court of Kenya. Ordinarily, I practice in Machakos, Nairobi, and the larger Ukambani, Kitui, Makueni. Yes, so where I get my bread and butter is within the legal practice, and I'm passionate about employment and labor laws, among other areas of practice. I'm an associate, a senior associate at JA Macau, and specifically the Machakos office, because we have several offices. So I'm based at the Machakos office, and I want to thank you all and hope that we are going to have a fruitful moment of learning. And back to you, Angela. Thank you.
Thank you for that introduction. At least they know where they can get you and find you should they need legal advice. Now we'll go straight into it. We keep our things short here. So, I'm sure the audience will be grateful for for this webinar. So maybe you can tell us. Let's start with the legal framework when it comes to leave. What is the legal framework in Kenya? You can tell us more about that. What are the laws? What is the legal backing? Thank you.
Very well. Thank you, Angela. Well, when we talk about leave, we are narrowing down from a very broad topic, which is employment and labor, and all that governs employment and labor, how you relate as an employee employer. Therefore, in any setup where we are talking about anything that governs a relationship that is statute controlled, our starting point must be the constitution. And therefore, the constitution we are going to borrow, the constitution has been put by some of our learned friends that it is a skeleton tool, yet it's the most important. In most cases, it will not give you what you want in details. It just gives you maybe an intro and then leaves you and or rather refers you to where you get your answers. So we are going to just borrow slightly from Article 41 of the Constitution. That is where we get the law on labor being mentioned. And I'm using the term mentioned because it actually mentions it. Talks about fair labor practices and all that. So after the Constitution has just mentioned it, you are referred to the main tool, which is the Employment Act. Employment Act, we call it CAP 226. Now, you don't have to worry about the caps and all that. Now that is where the lawyers will come in. Yeah, so but the major tool, which is now the statute that will give you all that you require as an employee employer intending or in a relationship, and that is employee employer relationship, you go to the Employment Act. So it's the major tool there. Now this act is also guided by other rules. We have the act. You see, now we have like hierarchy. We start from the constitution, we go to the main statute, which is now the Employment Act. Now the Employment Act also gets supported by other tools. Now we have the employment general rules. This one has been amended severally. We now work with the Employment General Rules 2022. There are rules that were amended to 2022. Then now we have all these. You will hear when, especially whenever employees get into trouble, you'll hear people talking about our CBA, our contract. The contract says this, the contract says that. The CBA, especially for instance, when we had teachers and their employer having problems, we'll hear them talking about our CBA. CBA is collective bargaining agreement. Now, those are also tools that also govern those areas of employment and labor, and specifically leave. Now, if we go deeper, we will get specifically which article gives us, or which section gives us a talk on leave.
Okay.
So that
I
is it.
think all right. Thank you. You preempted my question. I was about to tell you, I was about to ask you about what a CPA is and in relation to these professions we see, because I think our viewers normally hear CPAs and people striking, doctors striking, teachers striking, and all that. So maybe you can tell us what is a CBA in full for our viewers to hear and also to understand what you said it's a collective bargaining agreement, but what is it essentially?
A CBA is essentially, like the name suggests, it's an agreement. So an employee will come in and enter into some agreement. Then this is an agreement they negotiate. They come into, they agree that this is what we are going to do, and this is how we are going to man our area of practice. This is how we are going to do going forward. Now, that agreement is usually a volunteer negotiated tool that then now comes in to rather govern how you are going to relate. So it is very specific to a specific category of employee. We have teachers having their own, doctors. So it is an agreement, and especially you enter into a CBA with your employer, that this is how we are going to work. This is what is going to be our minimum remuneration for this period. This is how increments are supposed to be done. If there is a problem, this is how we solve it. If there is an increment in salary, it provides all that. So it is an agreement. That is the bottom line. It is an agreement between an employer and employee, but it is not a contract. It is just an agreement on how you are going to relate with your employer, and it
Okay,
is
that
now collective. Yeah, it you see the difference. And just so that we don't confuse it, a contract is specific to an individual. So this is Ramadan and his employer. But now CBA is, if it is if Ramadan is, for instance, a teacher, then now a contract will deal between Ramadan as a teacher and his employer as TSC, for instance. But if it for it to qualify to be a CBA, now we have teachers coming as a collection, not an individual. Then now that agreement that we sign as teachers, as lawyers, as doctors with our employers, various employers, now that becomes a CBA.
thank you. That is well understood. Thank you. You almost sound like a lecturer. That's what I like. So now maybe you can tell us in passing or briefly what are the types of links that are there or that the law provides for. Just we can mention before we now start going in depth.
Yes, the various types of leaves that we have under our laws of Kenya, we have the most common, the annual leave. Annual leave is one of them. We have maternity leave for the ladies. We have paternity leave for the gents. Then now we have other leaves that are really not prescribed under the laws expressly, but then they are there. We can have compassionate leave. Of course, we have sick leave, which is also in the laws. The others that are not mentioned, we can have compassionate leave. We have leaves like pre-adoptive leave. We have um, various. Now there are some that I don't want to go into unless we are going to dig deeper, because now there are also leaves based on your agreement or contract. So we can have contractual leaves. Now this is personal between you and your employer. but we may not have them in the laws.
Very well. Okay, so now maybe you can take our viewers through the annual leave as per section 28. And as you take us through that annual leave, are public holidays catered for, or how are they treated? And also, do we count the weekends when we talk about annual? Please clarify on that as you teach us more. Thank you.
Thank you, Angela. Now, annual leave. This is the most common that we hear, and especially when we get trouble with leave. This is where we usually have a bigger problem. From its definition, we can define annual leave as it is being out of work, which is authorized. In the most basic term, we can say it is being out of work, which is authorized by the employer. And the good thing or the good news is you get paid for it. So you are out of work, you have been authorized by your employer, he is aware you are not coming to work, but you still get full salary. So the bottom line is there is full salary, the employer is away, but you is aware, but you are not working during that period. Now, the perimeters around leave, and that is why people usually have problems. Leave is provided for under the law, and specifically, Section 28 provides for annual leave. Now, you as an employee, you need to inform your employer when you intend to have your leave. And before I forget to mention, we have had courts make decisions around leave and specifically annual leave. And that is something that is very important. I want it to sink that if you don't ask for leave, the courts have said the employer has no obligation to compel you to go on annual leave. And therefore, you come to my office as an advocate and tell me that, I've not gone on leave for the last 4 years. My next question to you will be, did you ask? If you don't ask, the courts have said it is a right. But if you decide to sleep on your right, nobody is going to wake you up. They are going to give you another blanket. You're going to cover yourself, you're going to sleep. So it is upon you as an employee to ask for leave. Now, public holidays and what we can refer to as rest days, they don't count as part of annual leave. Now, the minimum number of leave days that are provided for under the law is basically 21 working days. So this is exclusive of weekends if your kind of job does not require you to work on weekend. So it is 21 working days, and that is the minimum. So you can have, based on what you agree with your employer, even if you decide to go on leave for a whole year, if as long as it is paid, you can count it as annual leave. Who cares? But then it is at least 21 days. So if you're not going for leave at least 21 days, then you need to visit Angela or myself to compel your employer to either pay you for your leave or let you go on leave. But remember, did you ask? Because now that is a question that has become very problematic. If you don't ask for leave and your employer keeps quiet, you might lose on that. Then, most importantly, there is what we call continuing injury. Now, continuing injury, I want to mention just because we are talking about annual leave. When you keep quiet about anything that is affecting you in your work environment, and now we are talking about leave. Year one, you didn't go on leave. Year two, you didn't go on leave. Year three, you didn't go on leave. Of course, the law allows you to carry forward your leave. So you can say, because I didn't go on leave, I want to be compensated in terms of say money, or I want to collect all these leaves and have them within a specific period based on what you agree with your employer. That one is there. Now, continuing injury comes in If you keep quiet beyond 3 years, then you lose anything that is beyond 3 years. So you didn't go and live for 6 years and you asked, you have proof, you were declined by your employer. You come after 6 years that you want to, have yourself compensated for the leave you lost. The law provides that you have enabled it by letting the injury continue. So you will lose the 3 years. So the maximum you can get is only 3 years. I don't know if
Yes.
I said a
Okay.
lot.
No, 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 no. We are following. We are following. It's quite insightful. You're sharing a lot of legal insights. Now, I want us to move very swiftly to maternity leave, and maybe what do female employees need to know when it comes to maternity leave, and are they entitled to full pay? And also, once a female employee takes maternity leave, can they thereafter proceed and take annual leave? Or annual leave now negates, or maternity leave negates annual leave? I don't know if you've gotten the question. Have you? Okay. Please proceed and help us here.
Thank you. Maternity leave is governed by Section 29, follows closely after the annual leave. Now, female employees are entitled to maternity leave of 3 months with full pay. That is the bottom line. Of course, the condition is that you are expecting. So if you are not expecting, then you don't qualify for maternity leave. Now, it is 3 months with full pay. Now, when you come back to work, you should not be what we would call demoted because you went away for 3 months and received, for somebody ignorant would say you received salary without working for it. No, the law provides that you are entitled, so it is a right. You come back to work, you should either be in the same position you were or at least go higher. In fact, a good employer should appreciate you for bringing another human being to the world. And I would perhaps recommend that going forward, when you return from maternity leave, you get like a promotion. Now, the perimeters is you need to, employee relationship is in itself a relationship. So there is the most important thing we call communication. You need to communicate early enough so that your employer is prepared psychologically, and also how you're going to be, somebody is either coming to step in to do what you are going to do during the period when you are away. So most importantly, you should ensure you give communication. Now, at least inform your employer that I intend, because now with the current technology, you can know when you are likely to have your baby, when you're likely, there's that period you can tell because of the technology we are in today. So you are supposed to inform your employee. You don't assume that kwani si ananiona nikiwa na mimba. No, you can't assume. Just let your employee, because and most importantly, for purposes of evidence, and this one we need to whisper, for purposes of evidence, so that in case either you come back and you find yourself, your desk has been removed from the corner office to the gate office, then you can connect that I was demoted because I requested to go on maternity leave, and this is my proof. You have your paper. So at least give notice of at least 7 days. At least you can decide to give, uh, 9 months notice, but so long as you give notice. Now, if you go on maternity leave, you don't lose annual leave. Those are two rights that are provided for under the law. So either you can decide to you go on annual leave, connect it to the maternity leave so that it is 4 months, but then remember communication in any relationship, and with the Gen Z world now, when we talk about relationship, we understand communication is key. All you can avoid so much trouble by just communicating, you know. So it does not take away annual leave, and you can decide to have your maternity leave connected to annual leave, connect it to sick leave. We'll come to sick leave. So long as you communicate and you agree with your employer, that is the bottom line. Yes.
Thank you so much for that. Okay, now maybe you can take us through now pre-adoptive leave. When maybe one of our viewers wants to adopt a child, what are their benefits and what is the entitlement regarding the law? Thank you.
Very well. Pre-adoptive leave, it's a leave that we introduced just the other day. It was an amendment to the employment laws, employment and labor laws. So we introduced it as 29A. So the law saw to it wise that if a child is born into a family, then the parents get annual leave, I mean maternity leave. Then now this one is also coming. How do we treat this new child? So the law introduced what we call pre-adoptive leave. So when you are going to adopt a child and you have gone through the preliminary stages of adoption, and that one also you might need to visit myself or Angela to take you through, uh, the law gives you at least 1 month. You are entitled to 1 month, which is counted as 30 days, 30 working days leave, to enable you do whatever you want to do, whether you want to call it bonding, whether you want to call it interacting with the child who is being adopted, because this is also a new child coming into the family. So there is that aspect. Remember, notice. Now, in pre-adoptive leave, because of the secrecy, how it is done, it is usually not a public thing. Unlike in maternity, where you needed to give 1 week notice, the law requires you then now to do 14 days notice. So you give notice to your employer that I am in the process of either adopting a child and I will require my pre-adoptive leave. So this is my, at least the bottom line, 14 days notice that I intend to, have a child, because it is actually having a child. It's not even like, it is having a new child in the family. So it is 30 days, 30 working days with a 14 days notice. So you ensure that you do that. Communication is key.
Thank you for that. Still under these types of leaves, could you briefly touch on paternity leave before now we go to sick leave?
Now
Briefly,
we are,
maybe paternity
yes,
leave.
this is now where we bring the men. For a very long time, men have been accused of, just working and I'm here doing blah, 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 blah. Section 29 wisely provided for paternity leave. Paternity leave is for men. You need to inform your employer that I am expecting a child, and it is also an entitlement under the law. You need to be excused from work for at least 14 days. So paternity, 14 days, that is 2 weeks. Still communication. Now, for the men, the law is very strict. Unless the employer allows, you are not allowed to go beyond 14. So if you do 15 and your employer is not aware, you cannot say that I only extended by 1 day. No, the law strictly says it is 2 weeks. You can connect it with any other leave. It is not supposed to be deducted from your annual leave. It is paternity leave. It is a standalone leave. So for the men, you have, if your spouse is getting expecting a child and the child is there, you need to you'll be given 2 weeks, but then also importantly, you need to have proof that you're expecting a child. So maybe you can perhaps upload something, a document that shows or communicates to your employer that you are expecting a child and this child is, you are the father. So whether it is birth notification, whether it is a certificate from the employee, from the hospital, treatment note, something And my view, I think why the law it was very strict that it is only 2 weeks per child, because men are men. Whatever you do with that information, it's up to you.
Yeah, Akili. Okay, yeah, we have had. Now let's go to the most common type of leave that maybe most employees know of, sick leave, and some even abuse it. But let's tell us what sick leave is and why it's provided for under the law.
Thank you. Actually, when we talk about sick leave, and this is the most misused leave, yeah, you have to loud that. It is provided for under Section 30 of our laws. Now, Section 30 provides that when you're in an employment setup and you have worked for at least 2 months, you are entitled to at least 7 days sick leave with full pay. So 7 days you're out of work, you are sick. You have proof that you are in fact unwell, you are in the hospital, you are sick. Then 7 days you are entitled to getting full salary, full pay during that period. If unfortunately you are not recovered by within the 7 days, the law gives you an extension of another 7 days. But now with the now the second 7 days, you are supposed to get half salary. You're supposed to get half salary. So that is your entitlement for every year worked. So you every 12 months you have 7 days full pay, 7 days half salary, and it is equally you qualify after working for a period of 2 months. Now somebody would say, if I start my new employment and 1 week later I am genuinely unwell, like I said, it is a relationship. It is a relationship. And therefore, your employer is not going to say, you have not worked for 2 months, so you can't go on leave. Remember, it is not also automatic that in every 12 months you have worked, you are going to get sick. Nobody wishes to be sick. So your employer will accommodate you based on the relationship you have. You see, the law says that every 12 years worked. So you wouldn't say that I need to work for 12 months, sorry, 12 months, not 12 years, 12 months, then now I get my leave. No, it can fall anywhere. But cumulatively, it is 7 days with full pay, 7 days half salary. So maybe in January you are sick, you took 2 days, you shouldn't be deducted. You recovered in another 2 months later, you took another 1 day. So cumulatively, the employer is supposed to count. If they go beyond 7, then now going forward, additional leaves under sick leave, then you are supposed now to be given half salary, which is again another bracket of 7. So we have 7 full pay, 7 half salary.
Thank you so much for that. I see our time is moving on really fast, but I enjoy this conversation. Anyway, so we have like around 8 minutes, but we'll make do with what we have. So maybe you can tell our viewers what are the responsibilities of an employer and an employee with regards to leave. Yes.
As an employer, remember the minimums, because that is where the problem starts. If the law says it is 21 working days for annual leave, as an employer, it is your duty and responsibility to ensure that when an employee asks to attend that, you provide exactly that which the statutes provide. If it is 21, if it is 7, you don't deny. You'll avoid problems. As an employee, there is the issue of reasonable notice, because it is communication is key in any relationship. Now, as an employer, you must be fair when you are awarding leave, when you are approving leave, not even awarding, when you are approving leave. Because remember, it is a right, so you need to approve it in a manner that does not appear discriminatory. Otherwise, you are again going to have problems. Whenever there is a dispute as an employer between because whatever is governing you is the rules. We have the contracts, we have the CBS, we have all those parameters around what is governing you. Most importantly, do your part as an employer as per the law. That is the bottom line. As an employee, also don't just wake up and say, I'm entitled to leave, so I've decided. You send a message morning that by the way, I'm not coming for the next 21 days. I've decided to take my leave. You are going to have problems with your employer, and the law will protect your employer. So it is a double-edged sword. It will protect the employer, it will protect the employee.
All right.
So remember, yes, it is a relationship. Yes, communication is key. It is a contract. You agree. When you agree, things work smoothly.
All right. So before you now give us your final thoughts, maybe you can tell us the other types of leave. I can see those compassionate, the study leave, these other forms of leave that you are talking about, just in passing.
Yes. Thank you. Like I mentioned, there are other leaves. I insist on, this is a relationship. You can, you want to decide to advance your education, just approach your employer and inform them that I have this opportunity coming up, so I want a study leave. So we can have a leave under study leave as a leave under standalone. You agree whether it is going to be paid for, whether you might, there are institutions that even fund their employees when they get such opportunities. So we can have study leave, we can have compassionate leave. Perhaps you've lost a loved one, and or you are nursing a loved one in an hospital, so you're going to require a longer period to stay with them in the hospital. You need to communicate that I have this sick person, I need compassionate leave, or I've lost a loved one, I need compassionate leave for maybe a month to just condole and mourn the whoever's left. We can have leave such as administrative leave. Maybe you have something that you need to attend to. It is communication, it is whatever you agree with your employer, very importantly. Yes.
All right, thank you. Now we are coming towards the end of our conversation today. So please tell us, maybe you can give us our key takeaways from this conversation in maybe 2 minutes maximum.
Thank you. It is very simple. You are entitled to annual leave at least 21 working days. You can forget everything, but within a year, remember, you have 21 working days. Maternity leave for ladies, you have 3 months with full pay. For the fathers, you have 2 weeks with full pay. Remember, if you are adopting, you have 1 month with full pay. Sick leave, minimum of 7 days with full pay, and additional 7 days with half pay after 2 months service. Um, all other leaves, based on your relationship with the employer, how you talk, how you agree, you can convince or convene a meeting with the employer, request based on the CBA, based on the contract, based on whatever. But remember what I've mentioned, those are the minimums. So if you're getting 30 days, another one 10 days, 40 days, it is not discriminatory. The minimum is 21.
Thank you so much for this
And in
was
case of any problem, you can visit
yes.
Angela or myself.
Right. So we are coming to the end of the conversation today. It has been very engaging, insightful, eye-opening. I feel like I was in a labor law class and I was just learning and downloading a lot of content. So you are a very good speaker. You can be a lecturer, I guess, and you're also
Thank
fun.
you.
The viewers are going to be very happy while watching this. So finally, how can they, if they want your services, how can they reach you?
Very well. I'm available. You can come to our offices at J.A. Macau and Company Advocates, Machakos. We are along Industrial Area Road. And also I can share my office number, which is 0797 159412. You can just give me a call and or send a text. If you give me a call and maybe I'm engaged, just send a text. I will respond to your concerns. Thank you.
Right. Thank you so much, Wakili, for the insightful session. So we have come to the end, and we hope that you enjoyed this session, and see you on the next one. Thank you. Bye. Have a lovely day.